Hi, I'm David Hickey with ISA. I'm the Vice President of Government Relations, and I'm here to talk to you a little bit about the Patient Protection and Affordable Care Act and how it affects sign companies. I've had a lot of sign company owners ask me, how is this law going to affect us? What do we need to do to comply? And how much is it going to cost us? And hopefully we'll be able to shed some light on that today. Well, it depends on the number of full-time employees that you have. Essentially, what it means is that if you have 50 or more full-time employees, you are going to fall under the shadow of this law. If you have fewer than 50 full-time employees, then it's not going to directly impact you. And the law doesn't take full effect until January 1st, 2014, which actually is not very far into the future, as you might guess. So what you need to do is right away start talking to your tax experts, your attorneys, your human resources professionals to see what they can tell you so that your business can become compliant and be ready for New Year's Day 2014. Now, again, if you have less than 50 full-time employees, you're not going to be directly impacted by this law. However, or in fact, should I say, if you have 25 or fewer employees, you're actually eligible for a temporary tax credit to defray the cost of health care. So what you need to do is figure out, number one, if you have 25 or fewer full-time employees, they need to make an average of $50,000 or less per employee, and you have to already be providing 50% of their health care costs. If you satisfy all three of those elements, then you're going to get a temporary tax credit to help defray the cost of the health care coverage that you're already providing. If you have less than 50 full-time employees and you're not providing any sort of health care coverage, then everything's fine. You're not going to be directly impacted by the law. It's only if you're already providing health care coverage to those 25 or below, then you get some sort of tax break. Now, if you have more than 50 full-time employees and you are providing health care coverage to all those full-time employees, that's great. However, you need to find out if any of those employees are also getting some sort of coverage from their state exchange. State exchanges are supposed to be sort of an Orbitz or an Expedia for healthcare coverage, where individuals or small businesses can find out what sort of healthcare coverage is available. They can compare costs and coverages. There are deadlines involved with this. Open enrollment starts in October 2013, and the state exchanges become fully operational on January 1st, 2014, just like the rest of the healthcare law. So again, there's not much time left. And also, small businesses, employers, effective March 1st, need to give written notification to their employees about where they can find information regarding state exchanges so they can start looking for it. And ISA is going to be able to have the information for you to take a look at. Now, we talked about if you provide healthcare coverage to your 50 full-time employees or more, but one or two of them also get some sort of coverage through a state exchange, those employees are going to cost you a $3,000 penalty. So that's something that you definitely have to consider. Again, you provide healthcare coverage to your 50 or more full-time employees, that's great. But if any of them get any sort of coverage through a state exchange to supplement their coverage or something like that, that's going to cost you a $3,000 penalty. Okay, well, if your company has 50 or more full-time employees and does not provide healthcare coverage to all those full-time employees, then your business is going to pay $2,000 per employee minus the first 30. So in this scenario, a business with 50 employees would pay $40,000 a year in penalties, because 50 full-time employees minus the first 30 is 20 full-time employees times $2,000 per employee equals $40,000 in penalties each year. This is just one example of how confusing and complicated this law can be, and that's why you're going to need the expert advice from your lawyers and accountants and ISA. Long term, we don't know how this law is going to affect the cost of premiums or how it's going to affect the customers of sign companies. They have financial decisions to make as well, and is it going to filter down to their sign purchasing decisions? We don't know. We can be certain that more time and resources in dealing with red tape are going to have to be spent by small businesses. And the employer mandate is going to come into play for a growing business as they approach the 50 full-time employee threshold. As you might recall, a business that goes from 49 to 50 full-time employees is either going to have to provide healthcare coverage to all those full-time employees, or it's going to have the potential to face a $40,000 a year penalty. ISA is working to get sign companies as much information as possible about this law. We're working with other trade associations on Capitol Hill, such as the National Federation of Independent Businesses and the National Association of Manufacturers, to speak with elected officials and regulatory agencies to make sure that the voice of small businesses and manufacturers are heard. We also are going to have information posted on our website, signs.org, and that will include key points from this video, facts about the state exchange requirements that you need to show your employees, a calculator to determine if your business qualifies for those temporary tax credits and for how much, and several other online resources. Hopefully this information will, and others that we'll be adding as the January 1st deadline approaches, will help sign companies deal with this complex and complicated process. And our members, of course, are always welcome to contact us anytime with questions, and we'll do our best to make this process as tolerable for sign companies as possible.